Hi, this is Kyle Ingram. I'm an attorney in Washington, D.C. who represents federal employees, many of whom have reasonable accommodation disability issues that come up during the course of their employment. Before I get started on this, I just want to remind anyone who's watching that this is legal information only. This is not legal advice for you. You should contact an attorney to talk about any of the issues that you see presented here or that you otherwise are facing in your employment situation. And this is so this is just general information. None of this is really specific enough to take any action on anyways. But this is hopefully helpful for you to understand kind of the framework of what you're dealing with when managers are dealing with reasonable accommodations. Reasonable accommodations, I found lots of veterans need reasonable accommodations. Lots of normal employees need accommodations. People who get injured, people who get in car accidents, they end up needing accommodations. That is very common. And so this applies to a broad swath of employees. And not only that, as we're going to get into in this video, it applies to people who have relatively minor needs for accommodations, and those who have rather extensive needs for accommodations. Disabilities are not just the classic visible disabilities of being in a wheelchair, though it certainly includes that, right? Paraplegia, hemiplegia, those kinds of things. It goes all the way down to injuries that can happen to, for example, a wrist that leaves somebody unable to do typing for long periods of time during the day. Or if somebody needs telework, there's a variety of reasons why somebody could need telework. Those come up frequently. And so what I'm going to do today is walk through 5 myths that managers commonly believe about reasonable accommodations. And I think that it's important for people to know because in pretty much every case that I've seen, somebody has an issue with at least one of these myths, where their manager seems to believe one of these myths, or even their disability program manager, their EEO office. All of this becomes very problematic for employees because you don't really have a way as an employee of fighting against this. And there's certainly no manual out there that's going to tell somebody how to do this. Although, for example, the Army has an AR regulation on this, but it doesn't cover everything. And that's the way that the law is designed. Laws are designed to be flexible, to have interpretations that cover various circumstances. But what that means is also that at the edges, there can be disagreement about what the law is. Here, that's not really the issue. The issue is really that it's so flexible that the agencies can't tell people in advance what to do, right? The problem here is that managers don't commonly face these things. And people who need accommodations, they do. If somebody needs an accommodation for a permanent disability, that disability needs to be accommodated throughout that person's career. So, and you get a new manager, this happens not infrequently, you get a new manager and that manager simply doesn't understand what it is that reasonable accommodations even are conceptually. So we're going to cover some of this today. There's obviously more here than I can explain. And again, this isn't legal advice for you. It's just general information. If you have an issue with one of these, I'm going to put my contact information at the end of this. But really, you need to contact an attorney, somebody that knows their way around this. And for federal employees in particular, because this is geared only towards federal employees, a lot of what is in this presentation does not count necessarily for those outside of federal government agencies. If you're working for a state government, working for a private sector employer, if you're anything like that, you probably have at least slightly different rules. And some of these rules that I'm going to talk about, particularly with respect to telework, that has not been adopted generally by the courts. The reason why there's a difference here is because the EEOC controls a lot of this case law, and they don't follow necessarily what the courts are saying, although they take it under advisement, but they have their own litigation arm that interacts with the courts. And so they have their own standards that they enforce through the EEO process. One last little caveat here. If you're facing a failure to accommodate or any other kind of accommodation issue where you're not being accommodated, you need to consider going to the EEO office within 45 days. It's a complex analysis of what the 45 days is. I generally tell people file early and often. there's no reason to wait. If there's something that is unsatisfactory to you about your accommodation situation, in my experience, waiting doesn't help anybody. And so I just want to let you know, as a federal employee, you've got 45 days, quote unquote, to file. That is a pretty hard deadline in a variety of cases. You need to contact an attorney, but anybody who contacts me about an issue and they say, I'm waiting to talk to an attorney, don't do that. Contact your EEO counselor. If you don't know who it is, contact your HR office. It's very important to do that, because after the 45 days, you can lose your rights. So the first myth here that many federal managers have is they believe that reasonable accommodations are just about keeping you from getting terminated. They don't understand that there's an obligation that goes above and beyond that. And what we talk about in sort of the normal course of things in discrimination law is what's called a quote-unquote adverse action. So an adverse action is a loss of pay, a termination, a demotion, a transfer, typically not a lateral transfer, but if you have a significant change in duties, if you have a significant change in the work location, suspensions almost of any kind. There's a variety of different adverse actions. And frankly, the reasonable accommodation just does not fall within that rubric. For example, teleworking. Take the example of teleworking. It is not a loss of pay. It is not a termination. It is not a suspension. There's no discrete change in exactly what you're being paid, right? So, for example, in a termination or a suspension case, you're not being paid. That is very different when you're talking about telework, right? If they deny you a telework accommodation, you get paid as long as you're working. Or if you're taking leave, that's okay too, according to them. But that's not what the reasonable accommodation obligation is about. There's no requirement of having a separate adverse action. And I see this actually come up a lot with lawyers for federal agencies, that they don't seem to understand this, because they have in their head, and this is why I brought this up first, they have in their head this framework for processing discrimination cases. And failing to accommodate somebody is discrimination under the ADA. And the ADA is applicable to federal employees through the Rehabilitation Act. But this framework of discrimination is, it's called the McDonnell-Douglas test. You can look this up online. I'm not going to link to it, but because it's not relevant to reasonable accommodations, and here's why. That is specifically for disparate treatment under the anti-discrimination laws, where somebody is being treated differently based on a characteristic of theirs. So, for example, if, this is purely just an example, if individuals are being terminated who are African American, whereas whites aren't, right? So, for example, if you're 5 minutes late to work and you're terminated as an African American employee, but all of the white employees are always 5 minutes late to work and they never get terminated, right? That is disparate treatment. The African Americans are being treated differently than the white employees when it comes to whether or not they are being terminated for being 5 minutes late, or whether they're allowed to be 5 minutes late, essentially. That's not the situation with reasonable accommodations. There doesn't have to be a differential in treatment. This confuses almost everybody. Reasonable accommodations are not about whether somebody is being treated differently than somebody else. It is not about strict equality. It is about, a more general term, equity. It is about giving everybody the same equality of opportunity, right? There's no reason to believe that a black person or an Asian person or a white person or a person from anywhere has any different level of equality of opportunity just based on who they are. That's not true for people with disabilities. People with disabilities face significant challenges in the workplace because of their disabilities. And the law is there to require that they be given an equal opportunity to compete. So, for example, you could take, in the hiring context, a writing test. Right? If there is a if there's a writing test, you have to read and you have to write something. Well, if you have a sight disability, you may not be able to read that. And you would need, for example, Braille, right? The ADA requires that be given. That gives somebody an equality of opportunity to be hired into the position. That itself is not, that is a reasonable accommodation. That is a requirement under the law. But that itself is not in any way an adverse action where somebody says, I am not hiring you because of your disability, right? And there is, if you gave everybody exactly the same test with no reasonable accommodations, as used to be the way that this could happen before these laws were written, there is strictly an equality of opportunity. But we all know that that's not the same opportunity for somebody who has a sight disability. And so that's why the ADA was created. But a lot of lawyers, a lot of HR people, a lot of managers get the wrong idea with this, and they think that there has to be some kind of overarching, firing, termination, that kind of thing. It's not true. It's not true at all. There are plenty of cases where people are, it's small little things that people need to be able to do the essential functions of their job, and they aren't given it. And the fact that they can't prove that it has prevented them from being employed, that doesn't matter, right? It might end up in being somebody has a lowered performance evaluation, for example, even if that doesn't result in a change in pay. But if you go from a 4 to a 3, right, you're just passing, that's a big deal for you. And if that would be ameliorated by having a reasonable accommodation, that can be required under the law. And so people get this myopic view of what accommodations, what the law requires and what kind of accommodations are required. And that's why I've got here XB Stoli. This is a case, very recent case, where, and I cited a federal case here because I think they do a really good job on this of parsing how how reasonable accommodations are fundamentally different from the normal disparate treatment kinds of discrimination. Failure to accommodate is discrimination in itself. It does not require some kind of further showing. And I'm going to talk about that here in a moment in another case. But another thing that comes up with this is that this myopic view means that supervisors believe that there are the supervisors get a myopic view here about when reasonable accommodations are required. And the EEOC lays this out, and it may be in the statute, but it's definitely in the regulations, of 3 key points where employees are required to receive reasonable accommodations for their disabilities. First is at the application stage, which I just mentioned before. The second is for the essential functions of the job. This seems pretty obvious, but the requirement is that you provide a reasonable accommodation that allows an employee to perform the essential functions of his or her job. Not that you provide an accommodation directly for that essential function, but that you provide an accommodation that supports the accomplishing of that function. And that distinction can get lost a little bit, right? If you need an accommodation to be able to telework, that's going to cover your commute. That has really nothing to do directly with the performance of an essential function. But then, if you can't commute, you can't do your essential functions. So that is right. So if you can't commute to work because of a disability, and you have to telework, that is the key piece here, the keystone for you being able to do all of the other essential functions, right? So it's not necessarily directly related to an essential function, right? And a lot of supervisors, a lot of managers, a lot of lawyers believe, well, we don't have to accommodate things like commute. If they've got to get themselves to the front door, and then our obligation to provide accommodations begins. And that's not true, at least for federal employees. That is not true. And that's not been true for a long time. But people still believe that. All right. Last thing here that I wanted to mention is the accommodations for service animals. And many people need service animals in the workplace. service animals don't do any essential functions of the job. That's a clear instance where somebody does not need an accommodation specifically for an essential function, but it supports the ability to do that essential function. So there's a case out there, I don't have a site up here, where the agency delayed in providing a location for a sight-disabled person to take his service animal to relieve itself during the day. And so he had to cross a dangerous parking lot, which for him was particularly dangerous because there's cars running around and he wasn't able to necessarily see them. And so that's right. So he's asking for an accommodation, essentially for an accommodation. It's like an accommodation within an accommodation, but it's making his accommodation effective so that he can come into work. Because if he can't bring his service animal to work and safely navigate all of the things he needs to do for that service animal, he can't bring the service animal in. And if the service animal can't come in, he can't come in. Now, this isn't the case, but presumably he can't. So that's a situation where you have to understand how these requests for accommodation play out in reality and support the essential functions of the job. Okay, so I talked about three areas where reasonable accommodations are required. So the application process, support of essential functions, and the final one that virtually everyone misses is equal benefits and privileges. So the classic example of the equal benefit and privilege is going to be your holiday party. Participation in things that are not directly themselves the functions of your job, but are nevertheless part of your employment. This comes up somewhat infrequently, but it's definitely something that gets missed a lot. And it tends to be in the area of either profound disabilities where people don't understand how difficult it is for somebody with a disability to participate in programs, in things that just aren't set up for them. They weren't set up with these people in mind necessarily. And that's where, and it also comes up in smaller accommodations where smaller accommodation needs where people don't necessarily understand all the implications of that. A lot of times you need to combine when you're talking with HR, talking with a manager. It helps to be able to explain these things to them so that they can understand the outlines of your disability, what you can and can't do. Because otherwise, management just says, oh, it's not my responsibility. And they get this message drilled into their head, if there is one, that all that's required is accommodations for the essential functions of the job. How does this affect your essential functions, right? That's the question that they almost always ask. And I see a lot of EEO investigators ask the same question. And every time I see that, I just think in my head, you missed it. You don't understand the basics of this, and you're investigating something you don't understand. You're missing a lot of information here. Okay. I'm going to go on to myth number 2. As long as I'm trying to resolve the issue, that's not discrimination. So essentially, a lot of what happens in reasonable accommodations is put through, again, this framework of disparate treatment discrimination. And it's fundamentally different, and people don't understand that all up and down the line. From the lawyers all the way down to the managers and HR in between. Discriminatory intent is not an element of reasonable accommodation discrimination under the EEO laws. It is not something that you have to prove in order to demonstrate an illegal failure to accommodate. Well, what is that then? What are the elements? Well, broadly speaking, without going into too much detail, you have to show that you're entitled to the accommodation. You have to show that you requested an accommodation that was reasonable. So entitlement, that's a really deep topic. I'm not going to be able to go into that today. The second thing is that you request it, and it's been denied. And it is a reasonable accommodation. It's a plausible accommodation. So, for example, telework, if you've got a disability that requires you to telework, and you requested that and you've stated, I have a disability and I need a I need an accommodation for that, generally that's going to be sufficient to trigger the accommodation obligation. And there's more that comes after that. But at that point, the agency is responsible for either giving you an accommodation or giving you an alternative accommodation, or if they can't do either of those because it's an undue hardship, then at least documenting that it's been an undue hardship. So those are really the three outcomes here that are possible. If they fail to provide an accommodation, but they should have provided an accommodation, a judge isn't going to ask about discriminatory intent. That's not, at least not as part of the claim for failure to accommodate itself. And so, well, that seems a little inside baseball on something like reasonable accommodations. You're talking about, okay, well, what is a judge going to ask for? What does that matter? Well, it does matter, because a lot of times managers just think, well, I'm not discriminating here. I'm not treating somebody differently. They've told me all up and down. I've gone through all the trainings. I'm not supposed to treat anybody differently, and I'm doing just that here. I'm not treating anybody differently, right? You're getting the same deal that everybody else gets, because as soon as I give you a different deal, you employee, you're going to get somebody else is going to come and complain about this. Well, when you remove discriminatory intent here, that whole conversation that person just had with themselves is gone. It doesn't matter. It's irrelevant, right? The only question is, did you or didn't you provide the accommodation, and was the person entitled to it? And those are the two main issues here. Right? It's not about intent. So if this comes up frequently with dropping the ball, frankly. A lot of cases are coming up now about delayed accommodations, where somebody will request an accommodation, the agency will do the right thing and grant the accommodation, at least on paper, and then they'll wait. It'll be a year, before anybody even hears about, for example, ergonomic equipment. Oh, we sent this over to the person who handles this, and that person dropped the ball, I got that email, I just didn't respond to it on time, I just forgot about it. Well, in a discrimination context outside of reasonable accommodations, that might be a legitimate excuse. They call it a legitimate non-discriminatory excuse. That might be a legitimate excuse, right? You don't have bad intent, you just screwed up. Everybody screws up once in a while, right? So that is an excuse to treating somebody differently, right? So for example, I was using the example of treating people of different races differently with respect to being late by 5 minutes. If you come to work 5 minutes late and you're fired, but your white colleagues aren't, that looks like discrimination. But if the boss is too lazy to look and see if the other people were on time or not, then that can be a legitimate non-discriminatory excuse. So, you come in and he sees you walk in, he takes you aside, you're 5 minutes late, and while he's yelling at you and throwing his fists in the air, he misses that somebody else walks in, the white individual walks in, also 5 minutes late. In fact, later than you are, right? He misses that. It doesn't come to his attention. Right? If that comes up later, if you say, well, that's disparate treatment, the agency is going to argue it's not disparate treatment. He didn't know about this. The lack of knowledge here is really key. There was no intent. It doesn't demonstrate discriminatory intent. He would have fired that guy if he had known that guy also came in 5 minutes late. He was just too lazy. Good questions there about whether that's truly the case. But that's not what we're talking about here. That's the argument. That's the legal principle that your knowledge and your intent are relevant. Here in EEO reasonable accommodations area, you're only talking about knowledge. Is there knowledge of a need for an accommodation, of a disability, and that has requires some kind of change in the environment, right? That's it. If they know about it, they have to provide it, right? I mean, obviously there's a ton of caveats in there, but if they know about it and they're obligated to provide it, they have to provide it. And so the lack of any intent is just not relevant at all whatsoever to ultimately proving discrimination. And this comes up very often in litigation, where lawyers will try to say, well, there was no discriminatory intent. And I have to point out, just as here in Guzman versus v. Postmaster General, and there's tons of other cases out there like this, but this one's just very clearly stated. Finding of discriminatory intent is not required. So you can, all up and down, you can have 100 affidavits saying everybody involved did not intend to discriminate. Doesn't matter. Wouldn't matter. I mean, absent some kind of special circumstance, would not matter to a finding of liability. Might matter to a finding of good faith. But that's a different matter. That's a different issue, and that goes to damages. Okay. So, myth number 3. A lot of managers believe that if they simply provide some kind of accommodation, that's all that's required. That some kind of, the accommodation obligation is not just some accommodation, it is an effective accommodation. And that has been defined by the EEOC to be the more effective accommodation or most effective accommodation. So here's an ineffective accommodation. An employee asks for a ramp to be able to get into the office, from the street up to the office, the entrance to the office, and an elevator in the office. Let's say the building only has stairs, right? The agency says, we can't build a ramp outside. We're not going to do that. It's not a cost issue. We just don't want to do it. But we will install an elevator. We're going to do that next month anyway, so we're going to install an elevator. That's an ineffective accommodation because that only gets the employee, it gets the employee nowhere, right? It doesn't even get the employee in the building. The employee has to get into the building to be able to get into the elevator to get to the office. That's a silly example, but it's clear there to anybody who's been in an office building before what an effective accommodation is. Okay. A lot of times, agencies provide partial accommodations. They don't want to do everything that somebody asks for. And that's where they run into a lot of trouble because sometimes you need all of the elements of the accommodation request to work together to be able to do the essential functions of the job. So let's take somebody, for example, who's teleworking and has a need for ergonomic equipment, right? So if this person literally cannot leave the house and go to work, they cannot telework, and we're going to assume for this example that this person is perfectly capable of teleworking from home, as so many federal employees have found out since 2020 that they are. That accommodation then is, we're looking at this from you can telework and you want to telework and ergonomic equipment, right? You need both of those to be able to do the essential functions. If you're at home and you have both a disability that does not allow you to type using regular equipment and you cannot come into the office. So if they provide the ergonomic equipment at the office and they say you can come here and you can do it, that's not effective, right? You're still at home. The employee is still at home. If instead they say, yeah, we'll let you telework, but we're not going to give you the ergonomic equipment. Well, who's working at home teleworking who doesn't need to use a computer, right? It's kind of the fundamental thing here that they need. So that's kind of how this can work, that people think, okay, well, a partial accommodation is going to be enough. Well, sometimes it isn't. And oftentimes it isn't. Oftentimes these things are sort of interlocking. And sometimes the employee needs to just explain that to management about how these things all work together and why they can't do their job functions if they don't all work together, if they don't have all the different pieces of the puzzle. The problem is that many managers just think, well, if I give some kind of accommodation, this is going back to the intent thing. As long as I show that I'm trying, that's all that's required. It's not. It's wrong. You have to provide an accommodation that meets the requirements of the law. And if you don't do that, your good intentions, your partial accommodations, those aren't going to matter. Right? What matters is, did you comply with the requirements of the law to provide an accommodation? So you can see all of these myths kind of have it's not a single genesis, but they all seem to work together a little bit, which is, I don't really have to do a lot. I'm trying to keep everybody just on the same level. And that's not what reasonable accommodations are about. Okay, myth number 4. I only need to accommodate the essential functions of the job. I talked about this before, but it merits its own it's its own discussion again here. So one thing is, I mean, it's a process. Reasonable accommodations are for the entire life cycle of employment, not just for specific activities. It is supposed to make employment available to employees who have disabilities in general. It's too many managers, too many lawyers, too many HR people get this very myopic view, and they focus in on the essential functions. And that is definitely part of this. They focus in on the essential functions so hard that they don't see that there are other aspects of employment that are also affected. And so, again, I mentioned this before, and I'll just bring it up again. A lot of EEO investigators will limit their inquiry solely to how does this a reasonable accommodation that you requested enable you to do the essential functions of the job. It doesn't matter all the time. And not every one of the reasonable accommodations that are requested is going to be about the essential functions of a person's job. Probably the vast majority of them are, certainly from my experience they are, but it doesn't mean necessarily that you only accommodate essential functions. And this has come up in cases where even EEOC administrative judges have said, this is not about an essential function, so you don't have an accommodation obligation. And then the EEOC has to come in and reverse them and say, no, you're wrong. It's not just about that. It's also about, for example here, volunteer activities. You have to enable somebody to enjoy the equal benefits and privileges of their employment, right? So equal benefits and privileges has nothing to do with essential functions, right? And so I see a mistake in this presentation here. It's supposed to say includes volunteer activities such as working at an air show. And that's what happened here in this FAA case from 2003. There's a gentleman who was working for the FAA. He was wheelchair bound. And he couldn't get his wheelchair into a trailer that they took from air show to air show. It's a totally volunteer activity. You know, if you know people who work at the FAA, they love airplanes, they love flights, they love doing these air shows. They want to share their passion with other people, and that's what this guy was doing. But he was stuck because this trailer that they would take from air show to air show didn't have wheelchair accessibility. And they did actually try to make some accommodations, but critically, they didn't make an accommodation that allowed him to actually get into this trailer with his wheelchair. And he had to, it wasn't quite clear from the case, but it was something like crawl into this trailer. It's a kind of thing that as a human being, you think about that and you say, I really wouldn't want anybody to have to do that to themselves, right? That's not something that I certainly don't want my government forcing people in a wheelchair to do something like that in order to undertake volunteer activities. So, but this is totally volunteer, has nothing to do with somebody's essential functions, right? This is just something he does on the weekend along with the other people he has at work that he works with. So this is something where I think that there's a lot of room for improvement in how agencies treat this and how they understand what the scope of the accommodation requirement is. Okay, so number 5. I will get to it at some point, and that's sufficient. This is about delays. Delays in providing reasonable accommodations. There's always a delay of some kind. Right? Just in principle, accommodations cannot be granted within microseconds of somebody making a request for accommodations. That being said, that's not the problem. The problem is that management will sit on requests. They will fight with people about requests. They will push back unnecessarily on requests. They will send a request, if they grant one, they'll send the paperwork to somebody and then wash their hands of it and say, it's not my responsibility anymore. Those can result in a failure to accommodate. And the longer that the agency waits on making the accommodation, the more likely it is that they are going to be found to have waited so long that it amounts to a denial of an accommodation. There's no bright line rules in this. There are a bunch of cases out there about what constitutes a delay, but there's no way to say, 1 week is too long, right? It really depends on the nature of the accommodation that is being requested and how difficult it is for the agency to be able to meet that accommodation request. It also depends on who's holding on to the paperwork. Is there a requirement of somebody to provide medical documentation, which is very common? If the medical documentation is outstanding, there's no obligation requirement. There's a whole bunch here. The timeline matters in these. But I think it's worth stating here, going back to the whole intent issue, just going through the motions without making sure that something happens isn't going to be good enough. Right? That's part of the delay. Sending a request off for ergonomic equipment, and then when that equipment doesn't show up in 6 months, not following up, something's gone wrong. Right? That accommodation is not being provided. And the obligation is to provide an accommodation, not to try to provide an accommodation. So the delay, the longer it goes, the more important this is, the less excuse that the agency has as to why this delay has gone on. The more likely it's going to be that the EEOC finds ultimately that this was a failure to accommodate. So I put here a case. There's plenty of cases out there where delays have gone on. And sometimes they're as short as a month. I mean, honestly, sometimes I can't imagine that it was, less than a week would be probably too long. It just depends on the circumstances here. But I think the broader point is that managers just don't put a priority on this, and they drop the ball a lot. And they go through the motions and they say, okay, we're going to do this. And then they fail to do it. And that's a delay, right? And that comes at the cost of the employee. That creates a situation where the employee does not have equality of opportunity. That's what the ADA is there for. That is illegal if it results in a failure to accommodate. If the delay is in reality a failure to accommodate. Of course, we can all imagine a failure to accommodate, reasonable accommodation request taking years to accomplish, and then finally it gets provided, right? And I've seen this with agencies that people will file EEO cases, and they'll scramble to get something done, right? Scramble. Oh, okay. Now it's time to really get this reasonable accommodation accomplished. Once we get it in, that will moot the complaint. It doesn't. And just because you eventually provide the provide the employee with a reasonable accommodation, that does not itself mean that the whole complaint goes away magically. All of that delay becomes part of the failure to accommodate. Now, whether that's something that ultimately is a failure to accommodate, that depends on the factors. But it is this myth that agencies, particularly management, has that says as long as I'm making a good faith effort, in their view, a good faith effort, that's all that's required. It's not true. So a lot of this is dropping the ball. One thing to understand with this is that reasonable accommodations work differently from intentional discrimination, the disparate treatment intentional discrimination, in the way that it is that the whole agency is really responsible here. So it's not just a manager who is responsible, although that person may be fully responsible for this, but the entire agency's actions. Right? So if the manager says, I did everything in my power, right, and I sent the request for, continue to use this example of ergonomic equipment. I sent the request for ergonomic equipment over to the person in the agency office that handles this, and I never got a response. But I shouldn't be held responsible for the failure to accommodate here. That doesn't work. The whole agency is responsible. Now, if the responsibility is with the employee or the responsibility is with some third party, that's different, right? But to the extent that the agency has as an obligation to make reasonable accommodations, the fact that one person did their best to try to make those accommodations does not make it acceptable if the accommodation isn't ultimately provided, right? So if there's some office that they need to reach out to and that office delays, and there's no excuse for that delay, then the agency can be potentially held liable. And this comes up a lot with, for example, disability program managers, because disability program managers, these are people who are, I'm not sure if they're EEO or HR, but they're one of those two. And these people are tasked with providing advice, questionable advice in my book, advice to managers as to how to handle disability accommodation requests. And they process a lot of this information. The DPMs the disability program managers end up sometimes giving very bad advice to people. And what that leads to then is a manager who's stuck there getting bad advice from a DPM and having to make a decision based on that because they don't have any other information. They don't have access to a lawyer. Unlike employees who can call up a lawyer like me and get some answers to their questions, they don't have access to somebody that they can answer, that will answer those questions for them and is knowledgeable about this area. And so they make a bad decision, and now they're stuck with an allegation of discrimination against them that they don't like. And they are, they've done something to try to push this ball forward, but they haven't done enough. And the DPM may be saying, well, that's okay. Just take your time and do it. And unfortunately, that's still discrimination. Even if you have the right intent, even if you're trying to do the right thing and you're just getting bad advice from people elsewhere in the agency, that whole agency model is what is causing the delay. And if it's the whole agency, that is still a violation. That is still a violation of the ADA to the extent that there is a failure to accommodate. So the last little bit here that I think is really relevant to talk about is just if you're an employee and you're asking for reasonable accommodations, and there's so many questions that go into this, and there's so many things that people get wrong. How can you use these myths? Well, just understand that the structure of this is different from what somebody might tell you. And so if you're talking to somebody in the EEO office, if you're talking to a disability program manager, if you're talking to a manager who seems to know what they're talking about, the reality is that they may not. These myths, I bring these myths up not because I've seen them once or twice. They're pervasive. Not everybody has them, but they're in a lot of different places. A lot of different people believe these to one extent or another. And they end up costing people the accommodations that they need. And sometimes that means that they cost people their jobs. Right? So, for example, if a lot of veterans out there who have back issues related to their time in the military, right? Injuries, things like that. And now they need accommodations when they're in the civilian workforce. Well, if you know anything about back injuries, they tend to be degenerative. They never get better and they only get worse. And the question isn't, are they going to stay the same? The question is, how fast are they going to get worse? Right? How fast is the condition going to go downhill to the point where the person can no longer work? And that happens to people. They can no longer work. And so a delay of a couple of years, if you say, yes, I'll get to it. I'll get to this. By the time management gets around to providing the accommodation, that person may no longer be employable. That person may have to go out on disability retirement. And I am not a disability retirement expert, but they don't pay out 100% of your employment salary that you would have otherwise gotten. Sometimes it can be very, very low. It's not enough to live on. So I am confident that talking to employers about these myths and about trying to dispel the myths is at least hopefully going to help somebody to get the accommodations that they need, to break through these myths so that you can get somebody to understand what it is that you need as an employee, and to get them to react to this in a timely way so that you don't have to wait. Because too often I've seen it that people have asked for accommodations, the agency has said, yes, absolutely, immediately, and then nothing. Radio silence for months. And requests go in again. Hey, I want to follow up on this. I want to follow up on this. Nothing. Radio silence again. Or they say we're working on it. And by the time the accommodation comes in, it's too late. Right. And they think, again, this is, along the lines of, oh, it's sufficient. Oh, you got the accommodation you requested. That's not sufficient. In fact, it really may be from minute one that if the accommodation isn't provided, that's not enough. Right. If it's a delay. Another thing that agencies do is they say, well, we'll process this when you get back to the office, or right, if you're on Fmla or something like that. That generally doesn't work. The accommodation obligation is independent of Fmla. It needs to go forward without that. If somebody needs an accommodation, for example, there's a case where an employee needed telework. She asked for telework as she's recovering from her surgery. So the first few weeks she was going to be totally unavailable. And then she said, I can do telework for the next 3 weeks. And the agency said, no, we're not going to do any telework. We're not going to do any accommodations with you until you're ready, fully ready and able to come back to work. Well, she sued over that and she won in front of the EEOC. Obviously, there are more details, but the point of that is that the accommodation obligation should not be delayed. The agency should not be delaying in providing accommodations and engaging in the interactive process. And there's a lot of times where they think they can just delay, and they're just wrong about that. So as an employee, you just need to watch out for that. Right? You should be pursuing these things aggressively in the context of, I want to get this accommodation. I want to get a decision on the accommodation. I want to move forward on this. I don't want to have delays. Talking about getting your doctors on board. There's a whole process for that. I'm not going to cover that here, obviously, because this video is almost over. But it's important to make sure that you're progressing along with this and you're forcing the employer to make decisions so that they can make the decisions in your favor. Now, if they make the decisions that are not in favor, you have to pursue that. And you can't just let them go because this is something that, reasonable accommodation is not discrimination per se. And I've heard EEO counselors tell people things like this. Well, if they're trying, that's all that's required. It's not. It's not required. And a lot of people just don't understand this. And I think I can't recommend enough. If you are having issues at your employer, at your federal agency employer, or any other employer, if you've gotten this far in the video, talk to a lawyer about this. Because these things they're complicated. They're not so complicated, but they're complicated enough that the average person is just going to have no idea what they're doing. And they're going to make mistake after mistake after mistake. And there's a famous saying that an expert is the person who has made all the mistakes that they can in a specific area. Right? That's what lawyers see when they read cases. And lawyers like me, we read cases all day long. That's our job, right? Not all day long, but part of our job is reading cases to be able to make arguments. So we see all these mistakes that are getting made. We get to learn from those other people's mistakes. It's always better to learn from other people's mistakes than to have to make your own. Don't make your own mistakes. Find somebody who knows what these mistakes are. Figure out how you can approach this accommodation problem the best way possible. And there are lots of things that an attorney can help you with that I don't have the time to cover with you today. But you should seek out the assistance of an attorney, even if it's just for a few minutes. To get somebody to provide you a little bit of direction can be more helpful than making a mistake early on, and then that mistake becomes a core part of your case, becomes a core defense from the agency, right? For example, failing to provide doctor's documents when requested. That's a common tactic that agencies pursue to push somebody, to push back on an accommodation obligation, because they'll say, okay, well, we need to have doctor's documents as to this. And if the person doesn't come back with the documents to be able to demonstrate their entitlement to a reasonable accommodation, that is a legal excuse for the agency. Far too often, agencies do that repeatedly. Well, this isn't good enough. This isn't good enough. This isn't good enough, right? And they'll kind of retreat behind those each time, trying to push the obligation back onto the employee without providing the accommodation. That, in a lot of cases, doesn't work. But each case is different. And that's why you need to have somebody who's been down this road before to be able to just point you in the right direction. And that can be super helpful in just convincing the agency to do the right thing. So, last slide here. Just mention this. Take action. Right? Contact somebody who can help you. This is my mug here. If you want to contact me, I've got my website there, and my contact information is there. You can sign up for a time to talk with me. I do them throughout the week. It's best if you sign up through this through one of the links on my website rather than trying to give me a call, because a lot of times I'm not available. It's a very small office. This is an area of law where there's so much confusion. I can't recommend enough getting somebody to help you out with it. I guarantee that these myths are being utilized in any decision that is coming up, almost certainly in any federal agency context, because they're just they're such easy mistakes to make. And a lot of this is just a level of laziness. People don't want to take the time out of their day to help somebody else, even if that person is legally entitled to help under the law. People are busy. It's very human, very understandable, but it's still discrimination. And that's what they're going to try to convince you. A lot of people are going to try to convince you that this isn't discrimination. And certainly when you get to the EEO complaint level in front of an administrative judge, they have an attorney there who is paid to convince you of that, whether it's true or not, right? I mean, how do you know that a lawyer is lying? Well, his lips are moving, right? It's unfortunately rather true. And that's where I think it's helpful to have somebody there who can cut through all of that for you, who can parse what they're saying and give you the feedback that you need. Not all reasonable accommodation requests are going to be required to be met. The obligation has a lot of caveats to it. You can resolve some of those caveats, for example, by having doctor's documents and things like that are that help you with specific holes in your application or your request. That being said, there are also lots of other issues out there related to disabilities that people just don't see. And they're very important. I'll give you a couple of examples. Being requested to provide medical information in the first place, that can be illegal, right? The request itself for medical information, for example, if somebody says, "Oh, you have a disability. Tell me about all of your medical conditions," right? Not relevant to the disability inquiry. That's probably a violation of the law. There's a fairly strict requirement for it's a fairly narrow scope of what federal agencies and employers in general can ask for from employees concerning their disability needs. It is not the case that it's an open book. It is certainly not the case that agency managers should be calling up doctors and perusing essentially somebody's entire medical history. That is a huge red flag, and that probably is illegal. Another thing is sending somebody for a fitness for duty evaluation. If you send somebody for a fitness for duty evaluation, it has to meet a lot of the same requirements as for just generally asking about medical information. There's a lot of constraints put on that under the EEO laws. Disclosure of medical information. So if you provide the agency with medical information and that information gets out, or even if it's just stored incorrectly, let's say it was stored on like on a computer file in a computer folder that was accessible to other people that they don't have control over, that's probably going to be a violation, right? You should not have to fear, as somebody who has a disability, a medical condition that requires some kind of accommodation, you should not have to fear that information is just going to be spread around, right? That information is just going to get out there into the world and everybody's going to know about it. And you're going to have to worry about, well, now supervisor X knows about it. Is he going to do something with it that I can't control? I have a lot of sympathy for people who have been in this situation. People have been devastated by disclosures of medical information, particularly to their peers, where it causes an exacerbation in the underlying condition. It just makes it worse. And it's terrible, but it happens. That's another thing that can come up in this context. There's also interference claims. Let's say you get a reasonable accommodation, your coworker doesn't want you to have it. Maybe because he thinks that you've got this accommodation and you are being given a leg up and you're going to get promoted ahead of him. And so he's going to do something to interfere with that. Well, interference claims exist. Interference with somebody's accommodation is itself illegal under the ADA. There's not a lot of case law about that, but certainly there are cases where that has come up. And that's something you also need to be aware of. And certainly a lawyer who practices in this area will be able to help you to understand, what that entails and if you actually have a good claim. So, my last point here that I want to get to is, beyond just having knowledge of kind of the general area where this is, the requirements of the law. And by the way, I didn't cover everything. The ADA covers a lot of different stuff that is just way too broad for me to be able to cover in this short video and that short discussion even about the other areas that I couldn't cover. That's not exclusive. There are more issues like what happens if you get excluded from the workplace under a direct threat argument or a direct threat policy. Well, that's if you got excluded from the workplace because of something that seems to be a disability, 100% call a lawyer. You need to figure out whether that is. But my last point is, there are always cases that are going to be better and cases that are going to be worse, and there are sometimes that there aren't cases at all. And sometimes you can fix cases. Sometimes there are things that you can do to fix a case, such as requesting a new reasonable accommodation if you're still employed with the agency. That can restart the process, and you can go through the EEO process again, and it's a valid claim. There's an ongoing obligation on federal agencies to provide reasonable accommodations to their employees. So if you end up having a situation where you are trying to, where you've requested accommodation, it's been denied, and it's simply been too long, right? A lawyer can help you figure out, hey, is this something that I can restart the process for, or is that decision set in stone? Typically, it's not set in stone. And so it's a good idea to talk to somebody. There's all sorts of good reasons to talk to somebody who sits around and thinks about this kind of stuff all day and has the materials, the knowledge, the experience to understand how these things work and can guide you through not just what are the legal requirements, but what is the whole EEO process. I've got other videos on my channel here about the EEO process itself. But how do you resolve these? Is it worth going to battle with somebody else over? What happens if they do this? What happens if they do that? For example, asking for somebody for accommodation documents, so medical documents repeatedly. No, this isn't good enough. No, this isn't good enough. No, this isn't good enough. That can actually be retaliation. And at the same time, a failure to accommodate, if that's what happens, if they delay any accommodation for that, right? What about interim accommodations? Are there interim accommodations? That's a question that depends on the facts and the circumstances, but that can be something that can be required. So I can't cover everything here. That's abundantly clear, right? This is only an hour. This stuff takes years to learn, right? And that's why the agency attorney who is ultimately going to hold on to this case, they get it wrong all the time because those people are generally, often generalists. Sometimes they come from an employment branch. Some agencies have a specific employment branch that people are attached to, or that lawyers are attached to, that they then get assigned to specific cases, such as EEO cases. And so they tend to have a better idea. But a lot of attorneys are just total generalists, right? They will have knowledge of these specific statutes in the area where it is. So, for example, like at the Navy, they would have knowledge of Navy statutes and regulations, the specific things to apply to their particular division or office. And then on the side, they may have some understanding of employment law in general. They may have done one or two of these cases. Most likely, they've never done a real reasonable accommodation case. And unfortunately, people, lawyers like me, and there are more lawyers than just I who can do this, but we know way more than they do. And we've got a huge upper hand. And the skill is not only in having the upper hand, but being able to turn that into leverage. And sometimes you can't do anything with these people. Sometimes you can't. Sometimes they just don't want to understand. Sometimes they think they're right. That's why I'm talking about these 5 myths. These 5 myths came up because lawyers told me about them. Lawyers told me they believed them. They told judges about these myths. So that's how I had to come up with this. And that's why I'm ticked off enough that I have to spend an hour talking about this online, because I think you deserve better. Employees deserve better than to have this. Fortunately, they don't get it. Certainly not from the agency lawyer side in the vast majority of cases. And not everybody believes these myths, but usually I'm dealing with one out of 5. So I'm going to end this here. I do think that this is an important area for people with accommodation needs. I think too often people with accommodation needs are just happy to get whatever they can, and then they walk away with it. Sometimes that's just not enough. As I said before, sometimes people end up having to leave employment, being impoverished by the fact that they weren't given sometimes a very simple accommodation like telework. Seriously, telework. People who now have to be on disability retirement for the rest of their lives because they weren't given telework. It's costing the U.S. government millions of dollars, because somebody didn't want to just check the box and say, yep, you can telework. I can't understand it. I don't understand it. It's beyond my comprehension that somebody would choose to do that as a supervisor rather than simply just comply with the requirements of the law. But it comes up a lot. Don't let that happen to you. Be the stick in the mud. This is your life. This is your one wild and precious life. Don't let somebody who simply doesn't understand this ruin it for you. All right. Again, this is legal information only. It's not legal advice for you. This has been a general discussion about the law and about how it can apply in certain circumstances. I've used some hypotheticals here. But do contact a lawyer to talk about these issues if you're facing them, because your situation is different from anybody else's, and it requires individual analysis. And there's not a lot of lawyers out there who help out federal employees in this area. I'm one of them. This is the bread and butter of what I do. If you're looking for help, go to that link there. I'll link it below in the notes. But just understand that it's really important to get this right. Maybe not even in the past, but in the future. Get it right so that you can continue your employment and you don't have to live every day with the worst parts of your disability that could be easily ameliorated. Thank you for taking the time to watch this video. If you need to get in contact with me, my website is right there.